Hello everybody, you have tuned in to Eric Jose on Making a Murderer on YouTube. I cover virtually any aspect of making a murderer. I go over the evidence, the documents, the photos. So if you like, stay tuned, and in the future I'll have many more videos besides the one you're about to see. Hello everybody, how you doing today? It's funny here on my YouTube channel. I go through the comments and stuff when I get a chance, and I do apologize recently, everybody, that I've been really super busy at work, and I've only been able to go through the comments pretty late at night when I get home. But I do love to go through them and I read them, but sometimes I get the people that don't agree with me. There's always going to be those people on my channel. I accept that they're there, I accept that they exist, I accept that they have their way of seeing things. But particularly one comment recently that stuck out to me was one of those people basically said that Brendan's the fact that Brendan's suggestibility is said that he is 95, he's more suggestible than 95% of the population. This person was saying that is complete BS, that there's no that's not actually factual or anything like that. And it got me thinking, like, what do you mean? What do you mean it's not factual? That doesn't make sense. Then I got to thinking about it. What it really means is that anything said by an expert for Brendan basically doesn't count. That's what that comment really meant. Because that's the expert that analyzed Brendan and put Brendan through a whole bunch of testing and did his evaluation, and he came to the conclusion that Brendan was very suggestible. And his estimation was that Brendan was more suggestible than 95% of the population. Now, you can possibly try to dispute that, okay, but really, how much can you dispute it? You clearly have a kid that's very suggestible, whether it's 95%, 85, 75%. I mean, the thing is that even if he's not 95%, we're still talking about a highly suggestible kid. So sitting here splitting hairs over how suggestible he was is kind of pointless. So, but this person got me thinking about how committed this person was to the fact that Brendan is guilty, and his confession wasn't coerced, and it was voluntary. Well, I was reading an article recently here, and I'm going to leave the link to the article down below. I'm also going to show you bits of it here today, about a case involving a gentleman by the name of Devontae Sanford. Okay, so in this article, we're going to hear a little bit about what Mr. Devontae Sanford went through. And the very interesting thing here, folks, is Devontae Sanford was a 14-year-old kid. Just mull that over as you're thinking, and what's going to be coming on the screen here in a second. So, here we go, folks. This is from an article by Laura Bazelon, The Innocence Deniers. When convictions are clearly wrong, these prosecutors don't just hinder justice, they actively work against it. This is from January 10th of 2018, and as I said before, the link to this entire article will be below in the information. Devontae Sanford was 14 years old when he confessed to murdering 4 people in a drug house on Detroit's east side. Left alone with the detectives in a late-night interrogation, Sanford says he broke down after being told he could go home if he gave them something. On the advice of a lawyer whose license was later suspended for misconduct, Sanford pleaded guilty in the middle of his March 2008 trial and received a sentence of 39 to 92 years in prison. 16 days after Sanford was sentenced, a hitman named Vincent Smothers told police that he had carried out 12 contract killings, including the 4 Sanford had pleaded guilty to committing. Smothers explained that he'd worked with an accomplice, Ernest Davis, and he had provided a wealth of corroborating details to back up his account. Smothers told police where they could find one of the weapons used in the murders. The gun was recovered and ballistics matched it to the crime scene. He also told the police he had used a different gun in several other murders, which ballistics tests confirmed. Once Smothers' confession was corroborated, it was clear Sanford was innocent. Smothers made the point explicitly in the 2015 affidavit, emphasizing that Sanford hadn't been involved in the crimes in any way. But Smothers and Davis were never charged. Neither was Leroy Payne, the man Smothers alleged had paid him to commit the murders. Through his attorney, Payne has denied any involvement. Instead, Smothers pleaded guilty to the 8 other killings. Davis, who was never prosecuted, was convicted on an unrelated felony in 2013 and could be released from prison in as early as July. Payne, who remains a free man, left Detroit in 2016 and his whereabouts are unknown. So, we basically find that this kid is still in prison and the prosecutor in this area refuses to correct her error. So, you may be able to see kind of what I'm talking about, where we can see right here that the prosecution, the attorney, the district attorney in this area where this kid was clearly not willing to accept the facts. And the facts were clearly pointing to the fact that that kid was wrongfully convicted, that he was not the one who did this. And it clearly points to the fact that he was coerced. I mean, it's just so obvious. All right? And you guys don't even know yet that to this day, the district attorney that prosecuted this kid still thinks that the kid is guilty. But we'll get to that at the end of the video. So, the thing about this is some of you may know a friend of mine, guy who started making some videos recently. His name's Mark Hodnot, and he posts on Facebook and stuff like that. He made a video recently where he basically just goes through like line by line from 1985 to the kind of through the 2005, 2007 and stuff, where he basically goes through saying we're all any kind of fail-safe that should have been there to go, wait, something's off here, something's wrong here, we need to maybe look into this a little more. Anything that was in there to make them question what was happening, how basically just line by line, how systematic this, whole snowball basically rolled downhill and gained more momentum as it went down, as it got heavier. Okay, and that's totally what happened here, because trust me, after the 1985 conviction, all right, now it wasn't just the original Manitowoc officers who had beef with Stephen, all right, who were willing to ignore an actual very disturbing stalker / rapist in Gregory Allen, because they were so hell-bent on getting Stephen Avery that they pinned something that he didn't do on him just because they didn't like him. And you can't deny that happened, because that's exactly what happened. And it's disturbing that to this day that they, like the district attorney in the case of Devontae here, they still believe that Stephen Avery raped Patty Bernstein on that beach, even though Patty Bernstein herself says it wasn't Stephen, and now knows it wasn't Stephen, and knows it was Gregory Allen. And yet those cops are still sticking to it. Okay? That's what this article means by innocence deniers. Innocence deniers do exactly what the Manitowoc County Sheriff's Department to this day does regarding Stephen's 1985 case. That's the reality of it, folks. So, when they're innocence deniers, they're not really doing their job. And we're going to get into now what is so unique about prosecutors, and or eventually we're going to get into here why it's unique and what their job really is and what it means to be a prosecutor, as defined by the Supreme Court of the United States in 1935. So, we're going to go ahead and see the next set of documents here now, and we'll come on back. Devontae Sanford, meanwhile, remained behind bars, locked up for crimes he very clearly didn't commit. Police failed to turn over all the relevant information in the Smothers confession to Sanford's legal team, as the law required them to do. When the information was leaked in 2009, Sanford's attorney sought to reverse his conviction on the basis of actual innocence. Wayne County Prosecutor Kim Worthy fought back, opposing the motion all the way to the Michigan Supreme Court in 2014. The court sided with Worthy, ruling that actual innocence was not a valid reason to withdraw a guilty plea. Sanford would remain in prison another 2 years. In an adversarial legal system, it's natural to presume that prosecutors and defense attorneys are driven by the same goal, to win. They aren't. In Berger v. United States, decided in 1935, the Supreme Court famously declared that the prosecution's ultimate goal is not that it shall win a case, but that justice shall be done. A prosecutor, the court wrote, is in a peculiar and very definite sense the servant of the law, the twofold aim of which is that guilt shall not escape, nor innocence suffer. That bold print is from another part of the article, not relating to this case, just so you know. Kim Worthy, a Democrat and the first black woman or man to serve as Wayne County's lead prosecutor, first took office in 2004 and coasted to re-election for a fourth term in November of 2016. The former circuit court judge has a national reputation as a trailblazing progressive. Last April, Essence named her its Woke 100 to its Woke 100 list to honor her efforts to achieve equality for people of color. Worthy's office, however, has repeatedly refused to admit error in cases like Devontae Sanford's, where there is compelling evidence of actual innocence. The Michigan Supreme Court's adverse ruling in 2014 wasn't the end of the line for Sanford. The court ruled against him on a technical grounds and noted that there was nothing to prevent his legal team from filing a post-conviction motion for relief from the judgment rather than making a direct challenge to his guilty plea. In 2015, attorneys for Sanford, who is black, did just that, and the Michigan State Police began to reinvestigate the case 1 year later. The police issued a 117-page report detailing compelling evidence that Smothers and Davis were guilty, that Sanford was innocent, and that Detroit's then Deputy Police Chief, James Tolbert, had lied to convict Sanford. It was at that point, 9 years into Sanford's incarceration, that Worthy finally agreed to his release. But only on the account of Tolbert's misconduct. She continues to insist that Sanford's guilty, pointing to his discredited confession. The state police recommended bringing perjury charges against Tolbert and murder charges against Smothers and Davis. Worthy declined in all three cases. I mean, she, number one, put away an innocent kid and then cast a blind eye to the actual guilty parties. I mean, it's unreal. In July of 2017, Sanford filed a civil suit under Michigan's Wrongful Imprisonment Compensation Act, and only 4 months later, the state attorney general conceded that Sanford was innocent. He had been wrongfully convicted and was entitled to compensation, but noted that Worthy's office has been consulted and disagrees. Of course she does. Julie Hurwitz, one of the attorneys who represents Sanford, told me that she was surprised that the state acquiesced so readily to this, given that the state acquiesced so readily, but then given the crush of the media attention the case has received, the Attorney General's office probably knew that fighting this would be a political bombshell. On December 21st, a judge awarded Sanford $408,356.16. And I'm going to go into right now why that could have been avoided. So, to get to what I mean by at least some of this could have been avoided, look, they had the information from Smothers 14 days after the kid had been sentenced. Okay? 14 days in. Think about how minimal the damage would have been right then. Had this district attorney done what she was supposed to do, as ordered in the Supreme Court decision of Berger versus the United States, and she should have realized that this kid was wrongfully convicted, and she should have been there making sure that the justice was done. But she wasn't, and to this day continues to ignore it and deny it. And it's because of prosecutors like this that exist that we have the tragedies that happen. Okay? I mean, this kid was 14 years old. This kid was, I mean, it's hard to imagine a 14-year-old kid who's going to walk into a drug pad and kill like 4 drug dealers or whatever, or 4, you know, whoever, you know, maybe, you know, just some, you know, pretty probably, you know, nasty characters. You know, drug addiction's not a pretty picture. So, I mean, this 14-year-old kid walks in and gets the jump on 4 people by himself. I mean, yeah. I mean, there should have been things ringing, going, "Hey, wait, whoa! This is weird. How's this work? How does this kid do that on his own?" And then, especially when you got 14 days after his sentencing, you're finding out, oh, here's the real story. Oh yeah, he led us to the gun and the ballistics match. Oh yeah, this is totally the guy that did that. He's admitting to it. He's even saying in an affidavit, this kid had absolutely nothing to do with it. That all gets ignored. But think about how much it would have been minimized if it had been set right at that point, 14 days in. When we have prosecutors and people in our government and in our judicial system that are unwilling to correct the mistake, even when it's only that young, or that when it's only 14 days old, before it really becomes something that could be a hugely expensive problem. They could have minimized it and set things right then, but they didn't. They sat on it, hid it, wanted to act like it didn't exist, until it had to go to the point where the kid spent 7 years in prison that he should not have been there for, that somebody else had admitted to, had led them to the gun that matched the ballistics for the crime scene, and yet he was in prison. I mean, when we have these kinds of things there that show us, so when you know, Manitowoc and all them are trying to tell us that, oh yeah, you know, it can't happen, that can't happen, you know, bull, it can't happen. As soon as it would happen in 1985 happened, okay, suddenly it wasn't just Manitowoc anymore. Okay, do you understand that? Because as soon as Stephen got out, it wasn't just the Manitowoc County sheriffs that had an interest, and the Manitowoc district attorney that had an interest in nailing Stephen Avery. It got bigger at that point, because once he was out, you had Peg Leitenschlager, who was sitting there going, oh, holy crap, she wanted to save her budget. She's looking at these potential people getting out of prison, and she's going, oh my God, oh no, there's no way. And so the natural knee-jerk reaction of the Wisconsin government, or with a lot of DOJ departments, is to resist, because the fact is that they don't want to cop to when they got it wrong, because then they have to pay. And that's a powerful motivation. Hey, say what you want, but that's a powerful motivation for them to get in line and go along with what started with a corrupt department in 1985. But now, as this thing, the snowball, as I referred to it in the beginning, has rolled downhill, it has now picked up more weight and more speed and more momentum. And there's more involved. The snowball is much bigger. That's what I'm getting at. And it's true. It's absolutely true. Peg Lautenschlager was absolutely terrified at the other potential Stephen Averys that were sitting in the prisons there, that were going to be wanting to get all their DNA tested and stuff. A lot of them, a good many of them had a good argument, a good case, and if the DNA came back in their favor, they were most likely going to be out. And Peg was looking at this, and she did not agree with Governor Jim Doyle. She was not on board with him wanting to do the right thing, having, the desire to set it right, because, hey, as it should, the thought of innocent people sitting in prison in that miserable existence when they didn't do the thing that they're there for didn't sit well with him. And he wanted to try to set that right. But as I said, the DOJ, which Peg was in charge of, kind of had a different idea, which also didn't pan out. But the fact of the matter is that paying Avery was not something that Peg or the Wisconsin DOJ wanted to do. And trust me, if you don't think potential millions is a motivator that can make people do things that they normally wouldn't do, that would motivate even people that we think are so incorruptible, like police officers or servants of the state, well, I've just shown you today exactly how rigid and really just not fair that a lot of these folks can be, or how unfair that some of these folks can be. Now, not all prosecutors are like the one we were talking about here today. Getting back to why the one person who was saying that it's complete, there's no actual evidence that says that Brendan was 95%. Oh, yes, there really kind of was. When the expert for Brendan's, for his defense came on there and said basically gave the evaluation of the test results from him testing Brendan. Look, you can't look at an expert and say, oh no, he's completely bull. You can't listen to a word he says. He is educated. He did go and go to school for that sort of thing, to be able to determine whether or not people are suggestible or not, or assertive, or this or that. If they go to school for that, you're gonna have to accept that they're somewhere near the mark. So it's just, to me, strange, because that really means to me that person who's on my channel is what you would call an innocence denier. I think that perfectly sums that person up. So that's about it for this video, folks. I wanted to go ahead and show you guys that disturbing story about what happened to Mr. Devontae there, and just how really, some prosecutors are in the way that they think, where it is actually win at all cost. And then I thought it was really, really important to see that there mentioned that the fact that the Supreme Court has mandated in 1935 that a prosecutor's job is not to win. It's to seek justice. Okay? And that means to not let a guilty person go, nor to make an innocent person suffer. And that's important. And that's what Mrs. Worthy had the chance to do in this case. Like I said, 14 days in, that could have minimized the damage so much. I'm sure that Devontae would have gotten something, for being, held for however long his trial was, and then the 14 days, but it would have been nothing compared to years. He ended up in there for 7 years and getting $400 and something thousand. So it ended up being more costly, a lot more costly. When if she had just done the right thing 14 days into his sentence, it would have been a lot different. So that's my take on it, folks. Just wanted to make everybody aware of this. As I said before, the entire article, which is very interesting, will be in the information below. And we'll see you later.